what is the best reason for not applying form analysis? So it seems to me, looking at the Supreme Court's cases, many of the cases that decline to apply form analysis are cases involving government speech. But the government here is not arguing that government speech is at issue in the Oval Office.
That's correct. I think this case does have elements of government speech, but we're not saying that it falls directly under that doctrine. To my mind, the best reason is because this is not a case in which someone is seeking access to a space. This is a case in which someone is seeking access primarily to a person. So if you think about, a classic case that's about access to space, take the Supreme Court's decision in Widmar versus Vincent. That was a case where the Supreme Court held that if a university opens its facilities broadly to student groups, it can't exclude a student group based on their viewpoint. It must admit all student groups, regardless of viewpoint, to use the facilities for their expressive purposes. Here, unlike the student groups in Widmar, the AP is not seeking access to, for example, the Oval Office to use that space for some purpose of its own, independent of the president. They want access to that space because the president is there. They want to observe him in that space so they can record and report on what he is doing. And so I think that makes that fundamentally different than any sort of case in which the Supreme Court has addressed forum analysis.
The finding of the district court that the AP is engaged in speech when it live streams or sends things over the internet to their editors or blogs or posts something from the Oval Office directly.
Right. So I think the district court's analysis there rested on a misapplication of this court's decision in Price. The district court read Price to hold that ordinary forum analysis applies whenever reporters engage in communicative activity on public property. That is just not what Price holds. Price doesn't say anything like that. Price was about non-communicative activity.
But Price concluded that even regulations on non-communicative First Amendment activity, that the government cannot discriminate based on viewpoint. And there was no viewpoint discrimination at issue there.
Right.
And Judge Henderson's separate concurrence is very emphatic that she joins because she understands the bar against viewpoint-based discrimination, even for non-communicative activity, to be unaffected by the court's holding.
Right. So that was the rule in that context. I don't think that rule applies in this context. I think if you tried to apply that rule in this context, it would be both over and under-inclusive. If you're going to take the position that anytime someone is invited onto public property and is allowed to text their friends or take pictures and post them on social media, that means you can't engage in any sort of viewpoint discrimination. I think that's a rule that's simply not going to hold up. That would mean the president couldn't engage in viewpoint discrimination in deciding who he invites, say, to the State of the Union address.